If you had a stroke tonight, right now, who could legally pay your mortgage tomorrow morning? Not who do you trust. Who has the legal authority to sign the check? According to the Consumer Financial Protection Bureau, without one specific document on file, the answer is nobody. Not your spouse, not your adult children, not your closest friend. Everyone is locked out until a judge says otherwise. And by the time a court steps in, the bills are already past due and the stress on your family is enormous. This is not a rare situation. The CFPB says court-run conservatorship cases are long, costly, and completely public for anyone to read. That means your family's private struggle turns into a courthouse file while the mortgage clock keeps ticking in the background. Here's the part most homeowners over 60 never hear until it is too late. There are 5 legal documents that stop this chain reaction before it starts. 4 of them can be handled without an expensive lawyer, and one of them hides a tax trap that can cost a family hundreds of thousands of dollars. We will get to that trap in a few minutes, so stay with me. Let's start with the one that would have saved the family in our opening story. It is called a durable financial power of attorney. A regular power of attorney sounds similar, but there is a huge catch. According to the CFPB, a regular power of attorney stops working the moment you become unable to make decisions. A durable one keeps working. That single word, durable, is the difference between your family paying the mortgage and your family begging a judge for permission. Here is the rule that catches people off guard. You must sign this document while you are still healthy and thinking clearly. If you wait until after a stroke or dementia, it is legally too late to sign anything. Think about that for a second. The tool that protects you only works if you set it up before you need it. There is also a free government option most people miss. The Social Security Administration lets you name up to 3 trusted people in advance through your My Social Security account at ssa.gov. It is called Advanced Designation of Representative Pay, and it keeps your benefits flowing to your family even if you cannot manage them yourself. Now maybe you are thinking, I already have a will, so I am covered. I have to gently stop you there. A will only takes effect after you die. It does absolutely nothing while you are alive and incapacitated in a hospital bed. That is why the durable power of attorney exists in the first place. They solve 2 completely different problems on 2 different timelines. But your will still matters enormously, which brings us to document number 2. Without a written will, your home does not go where you want it to go. According to state intestacy laws, the government decides who inherits, and their rules may look nothing like your family's actual situation. The Associated Press reports that probate without a will can drag on for more than a year and eat up over 3% of the estate's value in fees and costs. Let's put that in real numbers you can feel. On a $400,000 home, probate can cost between $12,000 and $28,000 and take 12 to 18 months to finish. That is money your children never see and time they spend in a courtroom instead of grieving in peace. A clear, updated will that specifically names the home shortens that timeline dramatically. Document 3 is where things get exciting because it can skip probate entirely. It is called a transfer on death deed, and as of 2026, roughly 30 states plus Washington, D.C. and the U.S. Virgin Islands allow it. You file it with your county recorder of deeds, and the key detail is this. You keep full control of your home while you are alive. You can sell it, you can refinance it, you can cancel the deed tomorrow if you change your mind. When you pass, the home transfers directly to the person you named, skipping probate completely. No year-long wait, no 3 to 7% in fees. Now I want to be fair here because some viewers will ask about a living trust instead. A living trust can be powerful too, and it covers more than just real estate. But here's the catch most people miss. A living trust only works if you actually retitle your home into the trust's name. If you set up the trust and forget that step, your home still goes through probate anyway. That is the single most expensive mistake in estate planning, and it happens all the time. So which is better, the transfer on death deed or the living trust? Honestly, the answer depends on your situation. The deed is simpler and cheaper for most homeowners whose main asset is the house. The trust covers more assets and can help with incapacity. Many families use both. Ask yourself, what are you really trying to protect, and from what? Document 4 often gets confused with the financial power of attorney, but they are not the same. It is called an advanced healthcare directive. According to legal guidance, your financial power of attorney does not cover medical decisions at all. If you want a specific person making your care choices, you need a separate document saying so. Here is a quiet tip that saves real money. Medicare covers advanced care planning conversations at no cost during your yearly wellness visit. You can sit with your doctor, talk through your wishes, and get the paperwork started without paying a lawyer a dime. But there is another reason this document matters, and it surprises almost everyone. Medicaid.gov confirms that federal law forces states to try to recover costs from the estates of people 55 and older. who received nursing home or long-term home care through Medicaid. In plain English, after you die, the state may come after your house to pay back what they spent on your care. There are protections that you should be aware of. States generally may not recover if you are survived by a spouse, a child under 21, or a blind or disabled child of any age. But outside those exceptions, your home is on the table. This is why planning healthcare decisions in advance is not just about your comfort. It is about protecting the roof over your family's head from a bill most people never see coming. Now we get to Document 5 and the tax trap I promised you at the start. This one is hidden inside the tax code, and it has quietly cost families hundreds of thousands of dollars for decades. First, the simple part. Homestead and senior property tax exemptions are not automatic. You must file an application with your county assessor, or you pay full property taxes every year. Over a long retirement, that adds up to real money that could have stayed in your pocket. Now let's look at the trap itself. It comes from IRS Section 1014, known as the Stepped-Up Basis Rule. Imagine you bought your home decades ago for $50,000. Today it is worth $400,000. A loving parent thinks, I'll just give this house to my child now while I am alive, to make things easier. Here's what the IRS does. When you gift the home while alive, your child takes over your original cost basis of $50,000. When they sell it for $400,000, they owe capital gains tax on $350,000 of gain. That is a massive tax bill for simply receiving a gift from a parent. But watch what happens if your child inherits the same home after your death. The basis steps up to the fair market value at death, which is $400,000. If they sell it shortly after for $400,000, the taxable gain could be zero. Same house, same child, same love? One path hands them a huge tax bill and the other hands them the home clean. Now, to be fair, the IRS primary residence exclusion can soften the blow in some cases. If your child lives in the home as their main residence for at least 2 of the last 5 years before selling, they could exclude up to $250,000 of gain or $500,000 if married filing jointly. That helps quite a bit in many situations. But for investment use, rental use, or a quick sale, the trap still bites hard. Inheriting remains the safer default for most families. Ask yourself, would you rather leave your children a house or a tax bill? One piece of paper filed in advance decides the answer. So what can you actually do this week without hiring an expensive attorney? There are 3 main steps you can take. Step 1, call the Elder Care Locator at 1-800-677-1116. It is a free service that connects people over 60 with local legal help. Step 2, set up your advanced designation of representative payee at ssa.gov and share your documents with the right people like your bank, your doctor, your healthcare proxy, and trusted family. Step 3, put a reminder on your calendar to review all of this once a year. Because life changes, laws change, and outdated documents can cause their own chaos. Now think back to that question at the very start. If you had a stroke tonight, who could legally pay your mortgage tomorrow morning? For most families, the honest answer is nobody until a court gets involved. These 5 documents exist so your family never has to hear those words. They do not help you after the crisis hits. They only work if you file them before it is too late. You spend a lifetime building what you have. These 5 documents are how you protect it. If you know someone over 60 who owns their home, share this video with them today, not next week. This is the kind of thing people wish someone had told them sooner. And because laws, tax rules, and Medicaid rules keep changing. Subscribe so you get notified the moment something shifts that could affect your home, your family, and everything you have worked for.